Hello everyone. So I believe all good. Okay. And I hope now you have started your studies on a full speed for exams. Okay. So but definitely while preparing for the exams we need to continue our study also with the rest of the topic and the units. So just continuing with the continuing with your third unit only. Okay. So today we will go for the another topic which is known as a contract of agency. Okay. So contract of agency, I hope you are able to see here also the meaning. Okay. It is a legal relationship where one person appoints another to perform on the transactions on his behalf. Okay. And under your Indian Contract Act 1872 it is counted as a special contract. Fine. Simple terms to understand, just take your own example. Yes, to show the assignment, sometimes you are not coming, you are handing over your notes to your friend and saying that you show on behalf of me the assignment. So nothing else, you are a principal and your friend who is going to show the notes on behalf of you, that person is going to become your agent. Okay, just for example I'm saying how the relationship used to work. Okay, so here we used to have a two party mainly. Okay, one is your principal and one is the agent. So definitely the principal who employs another person to perform an act. Okay, and who is being represented by another person in dealing with the third party. So now again continuing with the assignment one only. So just suppose you have appointed your friend as your agent, because you have given your notebook to your friend and told that go and show the assignment to the ma'am on behalf of me. So you are telling him to do something on behalf of you. So you are a principal. Okay, you are a principal, and third party, definitely I am your ma'am, and your friend is your agent. Okay, so you have actually appointed a representative. Next, who is agent? So definitely a person employed by the principal to act on his behalf. Okay, or who is going to represent him in the dealings with the third party. Fine. So that is your friend. Now your friend is going to tell me, ma'am, my friend due to so and so reason not able to come, so I am showing on behalf of him his assignment. Fine. So one is principal and another is agent. Principal who used to employs another person to perform an act on behalf of him. Agent who used to perform the act on behalf of someone. Clear? Now we have some characteristics or features also, you can say, of the agency. Very first, for anything, when I am saying that contract of agency, so definitely there should be an agreement. An agreement between whom? Agreement between the parties. And who are the parties? Just now we have seen principal and the agent. So an agreement between the principal and agent required. First feature, not a very tough one. Next one, no consideration is necessary. Okay, so generally we know very well that agents are going to receive their payment by way of commission. Whatever services they are going to render, for that they are going to get the commission. So your consideration not always necessary. And even in that for this example, a stupid example just now which we have taken, the assignment one will also work. If I am not wrong, your friend to whom you have appointed as your agent, if he or she is your very 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 good friend, then definitely they are not going to demand for any consideration, or you don't need to pay any consideration that yeah, you took my notebook, it was so heavy, you shown to ma'am and everything, so I'm paying you 50 rupees. Definitely these things never happen, I believe, if that person is your good friend. Okay, remaining I don't know. So what we need to just know that consideration is not necessary. Clear? Next is your intention of agent. So whoever is the person who is going to enter into the legal contract, okay, binding himself as a agent. Fine. So his intention should be very clear, that I am entering into this contract, okay, or relationship with the third party. Okay, but the deal is not related to me. Okay, I am representing the principal. I am representing my principal. Actually, I am creating a contract between the third party and my principal. Okay, so that is your intention. Capacity: the parties who enter into the agency agreements, okay, must have the legal capacity to do so, just like any other contract. Your age, like not the minor one, or not the insane one, not the insolvent one, such type of things. And these all mainly we used to say that at least principal should be the, okay, like principal should have the legal capacity. Okay, it's depend upon the situation conditions also sometimes for the agent. So these are your features. Okay, now we have to learn the types or kinds of agent. So broadly we can divide under two heading. Sphere 1 we are going here from the point of view of the extent of their authority, how much authority agent is having. From that point of view we have a 3 agents, if I am not wrong. Yes, so first is your general agent, okay, who do all the acts, okay, connected with a particular business, okay, connected with a particular business, just like your manager of the firm. So if you are a manager, you are going to do all the work related to that firm, so you will be a general agent. Fine. Next we have a special agent who do some particular act only, okay, or represent his principal in some particular transaction only. Very simple example: you have hired the agent to sell your house or to sell your motor car, okay, so after that there will be no relationship between the principal and agent. Work over, the contract also completed, terminated. Next we have a universal agent. So universal, everything, so that means it is a unlimited authority, will be unlimited and full power, okay, to transact every kind of business on behalf of the principal. So these 3 are your, sorry, really sorry for this, can't help, sometimes I forget, I don't know why, to go for the aeroplane mode. Yes, now it will be perfect. Every day, almost every day it happens. I'm really sorry. So now I think you are used to this. So we are talking about the kinds of agent. So general, who is going to do all the acts connected with a particular business. Special, who is going to act or represent his principal in some particular transaction. Universal, whose authority is unlimited. Clear? Next we have from the point of view of nature of work. Okay, this was your authority, how much authority the agents are having. This is what work and how much work the agents are going to do. So in that first we have mercantile agent, who like deals in buying and selling of goods, okay, like who is having a full authority either to sell the goods or either to consign the goods for purpose of sale, or either to buy the goods, or either to raise the money on security of goods, okay, behalf of his principal. Always keep remember, whatever you are doing, it should be behalf of your principal. Then we have our types of mercantile agent. One is factor. So factor is nothing, factor is also going to be the buy and sell, but factor is having benefit was factor will have the possession of good, and factor will sell it, those goods, on his own name. Okay, broker will also, who is going to negotiate and make the contract for sale and like purchase on behalf of the principal. But the only thing is, what difference between your factor and broker? Factor will not have the possession of goods, and factor can't sell it, broker will not have the possession of goods, and broker can't sell it on his own name. But factor will have the possession of goods and he can sell it on his own name. Okay, then we have a commission agent, very common agent. We always used to say commission agent takes commission. So same thing here, buy and sell and receive the commission. So help the principal to buy and sell the goods and receive the commission on behalf of that. Then we have the another one, that is del creditor agent, okay, who is considered of an extra commission, okay, like guarantee his principal that the third person with whom he enters into the contract on behalf of the principal shall performs their financial obligation. Okay, so here is what you can see in the very short term: if the buyer does not pay, then the agent will pay to the principal, and because of that guarantee he used to charge some extra commission. Fine. Then we have the another type, non-mercantile agent. So they are not going to do the buy and sell of goods. They are generally your insurance agent or advocate, and even sometimes wife also used to be a non-mercantile agent of the husband. Okay. Now we need to learn duties of an agent. See here, I believe you don't have to like by heart something. Just think as an agent what you should do as a good agent. Okay, duties will automatically comes in your mind. Very first, you have to follow the instruction of principal. If the principal is giving you any instruction, being an agent, you have to follow it. Fine. If not, then definitely some problems will arise. Then next is what? Whatever work you have given by your principal, definitely you have to carry out those works with the care and skills. How much care and how much skill required, you have to go for that only. Next, how much, like whatever accounts you are handling on behalf of the principal, you have to, at the end, you have to hand it over those accounts to the principal only. You are not going to keep those money. Okay. Then, whatever is happening, okay, please communicate with the principal that today this much sale happened or today this contract got booked. Each and everything you have to communicate with the principal. Okay. Then never ever deal on his own account. Okay. So don't think that his money is yours and start dealing. No, don't do that. Okay. And never ever make secret profits also from the agency. Don't do. It's a principal money, so it should go to him only. Okay. And whatever amount you are going to receive, pay those amount to the principal. Okay. Whatever amount you have received for principal, pay it to the principal. Clear? So these are your very simple duties of an agent. Another some list here also we have. Okay, so do not use the information received in the course of agency against the principal. So if you have some secrets, kindly don't ever use it as against of principal, please, which generally in practical terms people used to do, but that's not the duty of the agent. Okay, if you know some secrets related to that agency, please keep it with you. Don't use it against the principal. Okay, then always protect the interest of principal. If he is going to die or if he is going to become insane person, anything happens to him, like he is going to become like what to say, if he's not a proper perfect person, okay, legal person, to like he's going to convert as a illegal person to enter into contract. So after that, please don't use all his money and everything for your benefit. Still try to protect the interest of principal. Okay. And duty not to delegate the authority. Don't do that. Okay, that you are already agent and then you are going to deliver, like you are going to delegate your all the work to somebody else also, or your authority to someone else also. Okay, so don't do that also. It was your work, so you have to only complete. Then we have some of the rights also. Don't worry, you have being an agent, you had so many duties, but definitely each coin used to have a two face. Okay, so agent is having some rights also. Very first right, if agent is going to bear any expenses, okay, to take care of the interest of principal, definitely he is having a full right to reimburse it. Okay, and agent is having a full right to receive the remuneration or commission. Okay, and then like wherever it happens that agent has gone for any loss, okay, for lawful acts and all, then indemnity, okay, the agent is having a full right to get those losses termed as a good by the principal. Then if anything you have did, okay, in the good faith, and again some problems arise, again some losses arise, so you have a full rights to get it good by the principal. Okay, and if you got injured because of principal's negligency, definitely principal has to pay all the financial charges, okay, to make that injury good and to make you again back the perfect person. And you have the right of particular lien. So being an agent, if you have something in your possession and the principal is not doing the payment of your expenses or remuneration, or not making your any losses good, where you have always gone for the principal, so definitely you can retain that item until and unless principal is not going to do the payment, whatever you are lawfully you should receive from the principal. Okay, so until and unless the principal is not going to do the payment, you can retain those items with you. Clear? So now the thing is creation of agency, how we used to create the agencies. Okay, so basically it is like how contract of agency is going to be created between principal and agent. So very first we have agency by express agreement. Okay, so whenever agency by express authority arises, where an express authority is given to the agent by spoken or written words. Okay, so just like a express contract one. Okay, where the parties are going to spoke, or where the parties are going to write the things, terms and conditions, and entering into a agreement. Okay, contract. Like just for example, like A is going to appoint B to manage his business, okay, by executing the power of attorney in the favor of B. So definitely again the relationship of principal and agent has been created between A and B by the express authority, because A has made the what? A has executed the power of attorney in the favor of B. Okay, then next we have agency by operation of law. So it is what? It arises where the law treats one person as an agent of another. Okay, now as you all are in final year, so definitely on the first year of your BCom, definitely you have learned about the partnership form. Okay, so whenever the partnership form used to get formed, every partner becomes the agent of other partner. Okay, every partner becomes the agent of other partners, and these all types of agencies arise by operation of law. Clear? Next we have agency by ratification. So ratification is something like you are going to make corrections. Okay, we can read here, also known as a ex post, okay, facto agency. So here what happened, your principal, okay, and wait, before like what happens here, we just need to know little bit things. Okay, ratification is actually something which is going to approve the act. Okay, approving the act which is done by an unauthorized person. Actually the person didn't had that authority to do it, but after that the person who is having the authority, he's approving that act. Okay, that is ratification. Fine. And it arises when a person ratifies the unauthorized act of another person, okay, pretending to act as his agent. You are not at all an agent, but still you are trying to show that you are the agent of that particular person, and you gone for the unauthorized act. Okay, so whenever the principal, the real principal, if he is going to approve that act, okay, then it is called as a ratification. Now just suppose you have money, okay, which is not yours. Just suppose, okay, so you are having money which I have given you to keep it with you for the safe one. Okay, you just keep it with you in a safe one. But what you did, you lend that money to the other party. You didn't have that authority. I haven't given you that authority. I gave you those money to keep it with you in a safe mode, but you lended it to the another person. Okay, and that another person is going to give me the interest, then I'm going to accept it, and then I'm going to say it's okay, fine, even though that person has lended you my money, he didn't had the authority, but he lended you, it's okay, we'll continue with this contract. So this is your ratification. You were not my agent for lending those money, but now I'm it's like implied one. Okay, I'm accepting that, fine, okay, correction, and whatever you did, I'm making it correct. Okay, so without authority, if someone is going to act as the agent of other person, and if the principal is going to accept this, okay, ratify it, approve that act, then it is known as a agency by ratification. Fine. Then next we have agency by implied authority. So understood one, huh? Implied means an agency which has to be understood from the conduct and behavior of the parties. Okay, so what will be coming here, like for example I can say, okay, just suppose you are staying somewhere else, okay, but your business in another place. Okay, so for example we can say that, okay, you are staying in a Bangalore but you have a business in a Delhi where you go occasionally, okay, and business used to managed by someone else. Okay, so when I'm saying that business is managed by someone else, so it's an implied one. Okay, implied authority, that you have given implied authority to that person to run my business or manage my business, which is my business, but you have given an implied authority. Okay, then next we have just next slide. So actually the implied authority one, we have a 3 types. Okay, so where very first comes agency by necessity. Okay, so whenever there is an actual and definite necessary for acting on behalf of principal, okay, and it's like impossible to communicate with the principal and obtain his consent or ask him that what I need to do. So, and whenever the act has been done in the best interest of the principal, okay, it is known as a agency by necessity. Okay, then next we have agency by estoppel. Okay, so whenever a person by his words or conduct induce third person to believe that, okay, a certain person is his agent. Okay, certain person is his agent. It's like by his words or conduct only it happens. Now just take an example. Okay, there is a one owner and one servant. Okay, and owner whenever he used to go to a grocery shop, he used to take his servant also along with him, and servant used to go and tell the shopkeeper, okay, I want this item, this item, this item, this item, this item, okay, all the item list, and then taking the bags, and then the owner used to pay the amount and servant used to go back. Okay, so shopkeeper always like every time if this same thing happens, then shopkeeper will always assume that, okay, on behalf of the owner, servant always comes and buy the items and the owner will do the payment. So this is agency by estoppel. Here what happening, whoever was the owner, okay, by his conduct the shopkeeper believed that the servant is his agent. Okay, then next we have agency by holding out. Okay, so it's like whenever a person by his past positive conduct leads the third person to believe that, okay, he is doing some act, okay, on his behalf, okay, or he is having the authority. Okay, like past time something did, and making the person to believe that whatever he is doing, he is having the authority for that. Okay, so in this also same kind of things may come, where again the owner has allowed his servant to purchase the goods, okay, on credit, and later the owner is going to pay. So whenever A is going to, like A and B, if I'm going to take A is a owner and B is a servant, so always the B used to purchase the items, okay, on the name of A, and A used to pay it later. So maybe possible. Fine. Something else also can happen, that one day B will, I don't want to take here something on, just for example, okay, that B will purchase the items and misappropriate those purchased goods and all. Okay, possibilities are there, but here what happening, holding out. Okay, see here by his past positive conduct. Okay, because earlier always 10 times 20 times B has purchased the goods and given to A only, and A has did the payment. So possible is there. But if in case B is going to run out now, okay, now B is going to purchase the items and run out, still A has to do the payment to the shopkeeper. Clear? Next we have mode of termination. So how we can terminate the contract of agency. So two main heading we have: by the act of parties and by the operation of law. So by the act of parties, very first is very simple. By agreement, if both the principal and agent is going to agree in a mutual agreement that see, we want to terminate this contract of agency, we both agrees for the same, so definitely the contract will get terminated. Next we have revocation by principal. Okay, if the principal is going to revoke the agent's authority, fine, so definitely like he has to give the some reasonable notice and reason why he is revoking, but principal is having a rights to terminate that contract. Then we have some types of situation where revocation of agency, like operation of law, under the operation of law. First one is simple thing: for which business, okay, you have made that contract of agency. If that business got completed, if that transaction got completed, or if the time got expired, whichever you have agreed, that is principal and agent has agreed, if that time came to the end and if the business got completed, then automatically the relationship between principal and agent will also get over. Okay, death of principal or agent, very simple again. If any one party is going to die, then there is no question, the things will get terminated. Insanity of principal or agent. So if anybody is going to becomes unsound mind, then automatically again the relationship will get terminated. So, and another we have still, I know little bit longer, but it's okay. There's no compulsion on you that you have to watch each and everything today only. You can watch whenever you want, in part by part. Okay, insolvency of principal. So whenever principal is going to declare as an insolvent, so again the agency relationship get terminated. And then there is some times like subsequent impossibility. See, when you have made the contract of agency, that time everything was correct, perfect, but after that something happened which is making the contract as a impossible to perform. So now just suppose like you hired an agent, you appointed an agent to sell your house, just for example, you hired an agent to sell your house, and that house only got destroyed in the fire. So now the subject matter is no more, so definitely no relationship is required. Which house now you want to sell? There is no subject matter. Okay, so business of agencies becomes lawful. Okay, so whenever subsequently the subject matter get destroyed, or for which purpose you have made the business, okay, contract, that only like by law it is going to be like now you can't do these type of transactions. Those things if going to be imposed by the government, imposed by the rules and regulations, so in such cases definitely you have to terminate your contract of agency. Okay, so this much for the day. I know little bit extra I have gone today, but as I told, you can watch this video in part. Okay, so thank you, have a nice day, enjoy.